Hello and welcome to Rights and Recourse, a program that tackles issues affecting your rights and matters of legal recourse. My name is Dumila Matez. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line at 011 714 5497, 011 714 5497 or 5498. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. A plea bargain is a type of agreement that was recommended by the South African Law Commission in 1996 to simplify Criminal Procedure Act. In this agreement, the accused is given an opportunity to plead guilty for a lesser charge. Plea bargains are aimed at a quick disposal of cases that could otherwise drag on for long, be costly, and create court backlogs. While plea bargains have been found to save court time, some have been skeptical of this option. Well, today, here on Rights and Recourse, we examine the effects of plea bargaining in our justice system. And to do that, I am joined by Senior Prosecutor Advocate Zeiss van Zyl, Mr. Mark Nogaga, who is a defense attorney, and we're also joined by Advocate and former Magistrate Khumani Giosa, who is in our Cape Town studios in Sea Point. We had also, that's it for our gentlemen. Good afternoon and welcome to Rights and Recourse.
Good day.
Good afternoon, Dumile.
Mr. Giosa, good afternoon. Are you there?
I'm here, but Dumile,
Kunjani? A question I want to know, Zeiss, let me start with you. What is plea bargaining?
Well, in your intro, you said is to bargain for a lesser charge.
It might not be so, isn't it?
It might not necessarily be so. Plea bargaining is a lot about the sentence, because through the years there was a informal plea bargaining system. That could only work as far as the charge is concerned, but there was always the need to have certainty about a sentence. And so this Section 105A of the Criminal Procedure Act came into being. It is called a complementary disposal mechanism, another way of disposing with a case. And yes, it is aimed at to deal with more substantial cases, not small cases, more substantial cases, usually with several charges, and to shorten court procedure and to lighten our court rolls.
Could plea bargaining be the same as admission of guilt?
Indeed, the beginning of the process of plea bargaining, as envisaged in Section 105A of the Criminal Procedure Act. The Criminal Procedure Act being almost like the Bible of criminal prosecution. It begins when an accused person shows willingness. Normally to the attorney, it is a little bit of a complex type of law that it is desirable that the person that wants to engage in a plea bargaining process be represented. And therefore, once a person, whether it is initiated by the state or by the defense, but the beginning of it, or rather the starting point, is when the accused person says, I am willing to admit liability. And then, like counsel has appropriately and very correctly pointed out, then the sentence becomes the most important factor.
Mr. Giosa, I didn't want to ask this question early, but let me ask it anyway. If there's an agreement of plea bargaining between the prosecutor and the accused, where does this leave the judge or the magistrate?
Look, Mr. Matez, one thing you must understand when it comes to plea bargaining, at the center stage, it's the prosecution who has carte blanche or who are dominant litis in terms of accepting a plea bargaining or rejecting it. Now, when it comes to the judge, he's sort of like the last person. He can only interfere with sentence. And that he can do that meremuto, though.
Meremuto, you guys.
He can only interfere with sentence.
You mentioned all sorts of difficult, Latin words here. Mm-hmm. What does it mean when it says I didn't even pick it up?
We unfortunately couldn't hear what he was saying.
Probably I must add this. He is saying everything that is done, the judge is the last person to hear of it around the issue of plea bargaining. But I want to know, I've always seen judges and defense lawyers and the prosecutors meeting in the judges' chambers and discussing something. Is this the kind of thing where that is discussed in the judges' chamber?
Can I come in here? One must understand the kind of criminal law system that we have. One has two basic systems. The accusatorial system, where we accuse. It is the state accusing. And the inquisitorial system, which is used basically in Europe, and where the presiding officer plays a more active role. In our law, here and there, for example, with bail, there's a bit of inquisitorial, but that is why the presiding officer sits and waits. He must now see what has happened. Cases are brought to him. He does not decide before it is put before him. But as soon as such a plea agreement is in front of him, it is the magistrate presiding officer's duty to check that all the steps that should have been done in this process has been done. Firstly, has the investigating officer's opinion been sought? Has the opinion of the victim, stroke complainant, or if the victim has died, the relatives, has that been sought? That's the first part of the process. If he's not happy that has been done, informs counsel of that, counsel have to go back and see that it is properly done. Then we come back. Then the presiding officer has a look at the plea of guilty. Is he happy that all the elements of the crimes have been admitted? If he is not happy, he says, well, plea of not guilty entered. You guys can stay in front of me, or you can go to another court. That is how it basically works. If he is happy with the plea, he still doesn't find guilty. He then looks at the sentence. In that regard, he may even ask questions. He may even call evidence. It doesn't often happen, I must say, but he has that right in terms of this section.
In other words, a judge can always reject a plea bargain.
Yes, and then he must decide whether the sentence that has been agreed upon is a just sentence. If he has the view that it's not a just sentence, he will inform the parties once again, and the parties then must decide, okay, we are now going to go through the whole sentencing procedure, or we step back from the procedure and the case must start de novo, which means anew in front of another magistrate.
Marky, quickly, before you answer that question, I want you to answer it with this one. We have pointed out what are the advantages of plea bargaining. Are there other advantages? Because somebody told me that if you might have, as a defense attorney, you might want to avoid the judge picking holes in your case and find a lot more against you. But if you go into a plea bargain, there's an advantage that you might not find a lot against you.
Indeed, there could be advantages. Not necessarily so.
No advantages? There could be?
When I'm saying there could be, like basically the law that is Section 105, capital A, in my opinion, is not a bad law. It actually is a good law. It's just that because it's fairly new, a law that is only 15 years old in our old jurisprudence of hundreds of years is a very new law. So it is still on its developmental stage where there could be uncertainty on certain things as the process goes on. But one thing that, before I go even deeper into what you're asking, Dumile, I want to highlight that the entire process that counsel is raising, the process of the judge or magistrate looking into the matter, trying to satisfy himself if the law has been applied properly and if it is just and justiciable, is done mostly in chambers. That is, it is not before a public court where now the magistrate will be at liberty to accept or reject the Section 105 capital A proposal in public. And at that moment, when it comes before the presiding officer, be it a judge or a magistrate, it is normally, generally, in a form of a document that has either been produced by the state or produced by the defense. This document now is put before the court to check on all the matters that that counsel has highlighted. Now,
just hold that thought. We'll come back to that because I want to pursue another thing between yourselves and Mr. Giyose. When we come back, we'll start with Mr. Giyose and then come back to Mr. Nogaga here. You might not be surprised when people talk about the counsel. Although this is not a court, but these are lawyers. If you'd like to join us in today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse, or email us at rightsandrecourse@sabc.co.za. Stay with us.
Information-hungry viewers stay with SABC News, as issues on the West are different from issues on the East or here in Johannesburg. So it is not surprising that people who follow the news know that there are two things for sure: that anything can happen, and SABC News will tell you when it does. Because we keep the nation fully informed. We are SABC News.
Welcome back, and welcome to Rights and Recourse. We are discussing plea bargain. Mr. Giyose, I understand, my research tells me you have been involved in this situation where you entered into a plea bargain, but tell me, how does this start? Do I call the prosecutor by phone and say, look, let's plea bargain? Or how does it start?
How it starts, Mr. Mateza, is by you putting up a proposal to the state, and if they have an open and shut case, that means if they are confident about their case, they would.
Yes, carry on.
They would reject your, they would reject your proposal.
They would reject your. On what grounds would you reject the proposal? If you see I can be a star here in this case, I will reject this because I'm going to be a star as a prosecutor.
If the proposal is a good proposal, if the sentence is a just sentence in my view, there is no ways that I will reject it, because everybody wins. 105A is a win-win situation. And unnecessary for your good name or to have the light shining on you, to have witnesses to go through this process, giving evidence is not a pleasant process, and to have weeks and months in court, no need for that. So we will not only agree if we have a weak case.
In other words, a plea bargain could save cost, time and money for the court.
Very much so.
Very much so. I think that is the most important, or rather the most prominent advantage of the plea bargaining process. You've got to.
The other question I wanted to ask Marky, whilst you are on the floor, is: can an accused be coerced into accepting a plea bargain?
You mean coerced by the state?
Coerced by any of the parties, even by. I've seen defense attorneys having difficulties in convincing their clients that they must accept a plea bargain.
It will be wrong, unethical, and illegal to coerce an accused person. It is not necessary. And if an accused person, even if perhaps on the basis of the fact that he does not quite understand the process, if the accused person wants to go to trial, even if it is not a clever decision, but it is his decision, he must make the decision freely, voluntarily, and without any coercion or false promises, or even promises for that matter.
Can I come in here? Yeah, we had a case in the High Court where...
Let me just, Mr. Giyose, you can come in anytime you want to come in. You can come in anytime into the discussion as you want to come in. Thank you.
Where there was such a plea agreement in a very serious case, and that person who went into the plea agreement then later on testified. When he testified, it was completely different to his plea agreement. The court said, what now? He says to the court, no, my attorney said to me, if we say this, Van Zyl will never accept it. Rather say this. He said, but it wasn't the truth. So this coercion or plying of statements, it can happen.
I have seen defense attorneys and defense advocates withdrawing from cases simply because they don't see the way forward if an accused doesn't want to accept a plea bargain.
Yeah, that's going to be my next point, Dumile. If then the legal representative is not happy with the manner in which the accused person is instructing him or her to go ahead with the matter, then he has an option. Just withdraw, recuse yourself from the matter, and let the attorney or let the accused person find a different representative or let him represent himself. But now to actually coerce him into changing his mind is defeating ends of justice, and which is a crime on its own. I know that it may be tempting for whether it's lack of experience or just being overzealous on the part of certain practitioners. It might be tempting for them because he, the legal practitioner, would have an insight into law and the factual circumstances of the case more than his client. It may be tempting for them to want to play around with the free will of the accused person, but the accused person his free will must prevail. If then his free will at the end of the trial is found to have been detrimental to him, then at least it was his own decision that he made, and he falls into a much deeper pit, then he has himself to blame.
Mr. Gyose, one of the other things that concern me here is the fact that how do plea bargains advance the pursuance of justice?
Well, Mr. Mateza, one thing that you must understand about plea bargaining, it's an integral part of the criminal justice system. And as rightfully pointed out by my learned friend, the counsel for the state, Mr. Van Zyl, it's always a win-win situation. Now, perhaps let me just unpack as to what plea bargaining, in essence, what it is. Well, it's an agreement between the state and the accused person. Now, the accused will then be pleading guilty, and he would know the sentence that he's going to get. So it's a win-win situation in that sense.
Do you want to add to that, perhaps, Marky?
Yes, to add on what my learned colleague has said over in Cape Town, particularly to your question, what does it serve any higher purpose?
Does it advance the pursuance of
justice? You see, the prosecution itself is an attempt by the justice system to deal with the ill that has been done to one, the victim, the community, and the society. So now, in bargaining, you are saying to the parties, you, the accused, you have done wrong, and you, as a state, there is, or rather, you, the victim, you have been wronged. Now you try to find a middle ground where these two can meet. And because these two parties are both consulted, and because these two parties, for the first time in our laws since 2001, are such active participants in the outcome of trying to redress the impasse. So now, when actually the agreement is agreed upon, both parties are happy. It means now the accused person is happy with what the punishment is going to get, and the victim is happy with the punishment that the accused person is going to get. There's a lot that could be involved in trying to appease. Let me make an example to me before you even ask me a question. For instance, where there has been money lost, a part of Section 105 capital A will be that the accused person pay back the money that has been lost, that has been stolen from the victim. Right now, then it means the punishment that will be meted against the accused person will be more of a redressive one rather than a retributive one, because he has caused damage to a member of a community. So therefore, the intention is to bring harmony and to bring back the flavor of that which has been taken away from the community.
Advocate van Zyl, in a case where there have been people who have come into this case amicus curiae, are they also consulted, or are they not consulted?
Well, we are happy to consult with whoever. This amici are not formally part of this
They're not formally part.
If they have sort of watching briefs usually. And there's no need, but you include as many as possible. I just wanted to come back to a point made earlier by Mr. Diorze, and that is you approach the state rejects as soon as the state has a strong case. I will not accept a plea if that plea is not in line with the evidence that I have in my docket. It will be wrong to accept a plea that says X happened while my evidence says Y happened. And it's on that basis that sometimes we cannot come to an agreement.
Another question I want to ask quickly before we go into another break is a plea bargain the same as giving evidence in lieu of indemnity?
Completely
No,
different. You're talking
not at all.
The Section 204,
Yeah,
there you
no,
are not convicted at all. And if you have satisfied the court that you have testified satisfactory, you can never be charged with that. But 105, you are convicted.
Mr. Gills, I seem to have wanted to say something there.
Yes, but yeah, my two colleagues beat me to it there. But yeah, when it comes to Section 204, you are granted immunity. It's not the same as pleading guilty.
I would imagine not all cases can be entered into a plea bargain can be entered in all cases.
No.
I would imagine.
It will be any case, actually.
Oh.
It's just that what is important is that there must be a meeting point between parties. That is between the offended, represented by the state, and the accused person, generally represented by his legal representative.
Can I just make this point that this plea bargaining process is a very work-intensive process. It's not a question of just dealing with it in, 5 or 10 minutes. I've had such negotiations where just the negotiations with the family took 3 full days, that the family would have their legal representatives also in there. So it is, you can often much faster deal with a single witness case, or you must come and plead guilty and get over with it. So it will be the more serious cases generally that we do this. I went into the statistics.
Before you go into the statistics, Advocate van Zyl, let's quickly go to a break. When we come back, remind me, you want to tell us those statistics.
Good.
If you'd like to join us in today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse, or email us at rightsandrecourse@sabc.co.za. Stay with us.
That goal was outstanding.
Made so much dust that I couldn't see, and I hit a stone, and we had a puncture.
Catch all these and more every day on Sports Live at 8:30 p.m. on the SABC News Channel.
Welcome back, and excuse me for that. And we continue our discussion here on SABC News about plea bargaining. Perhaps let me go to something else. Many people believe plea bargain is taking away the prosecutor's discretion.
Now, plea bargaining is everything about the prosecutor's discretion. Nobody can force the prosecutor, somebody outside the prosecution, to go into a plea bargaining. It is the prosecutor, the act says may. It is a discretionary process. It doesn't take away any of our discretion.
The other thing, I had a discussion, it's a case that's passed, in talking about specific cases perhaps. We've been arguing around the Pistorius trial, and many people are saying, had Pistorius entered into a plea bargain, then at least that would the sentence, the trial, the sentence would have been okay that he'd been found guilty of culpable homicide. That's a deal they would have made.
When you talk about any case, you do not know what happened behind the scenes. Was there such an approach made? We do not know. But it was from the outset clear that the state's approach was, this is a premeditated murder. So there was no ways that the state was going to look at culpable homicide.
Yeah, it actually gets to be a little bit dangerous to actually speculate on what would have happened under different circumstances. But one thing that I'd like to highlight, Dumile, is in line with just the what you just mentioned now, is that there could be possibilities that a law of this nature could be used or abused. And you must understand that, like any other machinery that the society depends on for operational purposes, the law is handled by human beings. So therefore, if it happens then that the people that are dealing with this particular law, I'll tell you why I'm saying this, the people who are dealing with this particular law happen to abuse it for reasons not so clear or unknown or personal, that are more self-serving, it does not make the law itself a bad law. There has been, for instance, there is a very general perception, like you have pointed out a few times before, that it would take away certain discretions from prosecution. Those are just general perceptions, that perhaps an accused person would go away, would get away with a lighter sentence. And there is even another perception that it takes away the court's discretion to decide on what is just. Now, but now the reality here is that all of these parties get involved in the process, including the judge or a magistrate himself. He is at liberty to say, I do not like what I see. I'm not going to be party to this.
I just want to go exactly to that. Mr. Giose, the issue here, I think Mr.
Yes, sir.
Nokaga has raised the issue of leniency. There's a perception of leniency towards accused, or the decision in some cases could also be seen as being erroneous. Is that the case?
No, that is totally not the case, Mr. Mateza. You know, when it comes to plea bargaining, it's what the parties agree to. It's the offense itself and what is the just sentence. And parties have agreed to that, and they are being held up to that agreement by a judge or a magistrate. So there's no leniency there.
Can a plea bargain be initiated by the state?
Yes, in terms of the Criminal Procedure Act, it does not specify who must initiate it. And in fact, there is nothing wrong with the state. And I've often had circumstances where a colleague, that is a prosecutor, would ask a defense attorney, even personal experiences, do you not want to consider a plea arrangement?
I want to come to exactly that. Many people have said to me, plea bargains actually take away what we normally see in court, what a prosecutor has to offer. In other words, it takes away the fact that, is this a good prosecutor or a bad prosecutor?
But unfortunately, Dumile, the carriage of justice and the outcomes of what justice comes to have got nothing to do with showmanship.
That's what we would like to see.
You know, the most important thing is that we have a responsibility on our hands. We have a society to maintain. We must
Let's get a prosecutor to answer that question.
Ask it again.
I thought you said earlier you lost you lost your knowledge of Afrikaans when you fell down on your head.
It's
but anyway, let me ask you this question. Doesn't it take away what we normally say as we sit as laymen? And we say, this is a very good prosecutor. Did you hear how we asked that question? Did you hear how we did this? Did you hear how we did this? Doesn't it take away that? It takes away the show for us.
But why should there be a show? The law should not be a show, in my view. My last case that I've completed, I indeed entered into a plea agreement. It took away the show for many people. It was a case last year, body that was found.
Oh no, I know. It's a case that's it's still in court.
No. It's not. It's not the body in the boot. It's another body that was found in a shallow grave close to Sterkfontein grave, and we had a wonderful investigation going to Port Nolloth and all over. There was a lot of show for us in it, but the right thing to do was get into a plea agreement in that case. There was 25 years imprisonment agreed upon. The family was happy with that. The law is not about showmanship. The law is about what is right.
I didn't want to go into the specific of any case, but what I wanted to find out is, Mr. Giose, is that the state goes into a great deal of expense in trying to get to the bottom of a case, and then at the end, then there's a plea agreement. People say, we don't trust this thing. What's going on here? Where's the credibility of the law?
Well, but Dumile, our law is credible, and prosecutors that prosecute cases have taken an oath, right? And once a matter now is in court, whether it's finalized by a way of plea bargaining or not, but what is important is that A, there's a conviction. 2, justice has been done. That's what is important to me.
The other question for me...
Sorry, can I quickly come in there?
Okay.
What's the difference between a plea sentence agreement and the matter where the state has put in millions and a lot of investigations and the accused pleads guilty? It's the same thing. There's, once again, not the showmanship. There's no difference, so there could not be any complaint about that.
You know, as much as I'm not going to go into specifics, I actually had a case once where I pleaded guilty to an alternative charge, and the state actually, when we were bargaining, the state was bargaining for a much higher sentence, and as a defense, we refused. We said no, we would rather go and take our chances with the court. We got only 20% of the sentence that was being offered, in terms of harshness, of the sentence that was being offered by the state.
Not necessarily mentioning going into specific of any case, one of the things that concerns a lot of people, which we're going to deal with in detail when we come back from the break, but I just want to ask this question. Despite plea bargaining being widely used in the criminal justice system, it is seldom praised because many people believe that people are getting away with murder. Criminals are getting away with murder.
You used a very strong word, Dumile, criminals. I'm going to craft my response particularly around that phrase. There could be type of offenders or accused persons that it would not be desirable to want to even go into a plea bargaining. A repeat offender, for instance, or a person who is probably being found guilty of a charge of, or rather charged with robbery for the 10th time or the 6th time, or a serial rapist, a person who murders for gain, you know, it just becomes undesirable in circumstances like that. So therefore, indeed, it would be seen to be lenient to criminals. The phrase criminal, in that instance, I'm rather depicting people that have spent their life, dedicated their life into making money by committing crime. Career criminals, for lack of better word. You know, where there is previous convictions and pending cases against them.
I'm sorry to be going back on this. Quickly, we've got a few seconds. And this, the thing is, Mr. Giosa, you can have the first bite on it. In other parts of the world, only a judge can agree to a plea bargain when the accused has waived his rights to a trial. Why are we not allowing the judge to make that decision? Why don't the two parties make convincing arguments in court and the judge take the decision, okay, we'll accept the plea bargain?
I think the answer lies in the type of criminal justice system that we have. And remember, I said some time ago, it is the accusatorial system. It is for that very reason. There were some suggestions that the presiding officer should be involved in this. There were some suggestions earlier. But because of the kind of system that we have, that simply could not happen.
Well, we'll explore that when we come back from a break. If you'd like to join us, you can call us on 0117145497 or 5498 or tweet us at Rights Recourse. Please stay with us. Welcome back to Rights and Recourse. We're still discussing plea bargaining. Mr. Giosa, down in Cape Town, you earlier wanted to say something,
yes,
and I interrupted you rudely. Probably, if you can still remember what you wanted to say, you can say it, because I want to come back to Advocate Van Zyl to carry on with what he was talking about earlier.
I think we were still on the topic of plea bargaining being widely used and at times being criticized. And I wanted to come in there, in that there's an old cliche that you cannot satisfy all people all the time. And that said, though, one thing that we must understand is that plea bargaining is a useful tool, and it's part of, or rather, it's an integral part of the criminal justice system. It saves time, meaning it saves a whole lot of taxpayers' money. Cases are disposed of quickly. A case that would ordinarily take a year can be disposed in 1 hour in terms of plea bargaining.
Gentlemen, the one other thing, now we can talk about it because it's public information. In his book, the former national public prosecutor advocate Fusipiko says he was criticized for having let off Mickey Schultz, Nigel McGurk and Faisal Smith because he wanted to get to the kingpins. Is that why sometimes plea bargains are done?
I would think so, but once again, it's one of those cases. What happened behind the scenes? All that mountain of information, one can just speculate. Why was it necessary to let the actual admitted murderers, or murderer at least, free to come and testify for the state?
On the face of it, it just becomes then, it just looks like it was very much of an exercise in futility, considering the fact that in the murder case concerned, no one was actually found guilty, including the accused person himself. And this is perhaps just a personal opinion. I do not understand under what circumstances we'll be looking for a solution in law using the two sections, because they are so divergent, Section 105 capital A and Section 204.
The other thing, Mr. Gerson, you can come in here if you want to. The Human Rights Commission made a submission to the Portfolio Committee when this little piece of legislation was being discussed and inserted into the Criminal Justice Act, into the Criminal Procedure Act, where they said they felt that in this plea bargains agreement, the victim is more than not consulted. But you said something to the contrary.
That the victims are not consulted.
Yes. But,
Look, let's give this a chance.
Can I chip in there?
Yes. Yes, go ahead, Mr.
But Dumile, one thing you must understand, when it comes to plea bargaining, the people that are central to it, it's one, the investigating officer, two, the victim or the complainant is always consulted, three, and then you have, on the other side, you then have the accused who is legally represented. So all of those parties, they sit down, discuss what needs to be discussed, and in terms of, A, the accused is going to be pleading guilty, in that the sentence that he's going to get is as follows. So everybody is happy, everybody has been consulted.
There's something
Even
else.
the family, though.
There's something else I want to throw into the mix.
Can I, before you get there, come to victims? This thing about victims and the rights of victims, we are acutely aware that the impression is that they are not properly attended to. As soon ago as, recently ago, as about a week ago, our office gave out an instruction that in all cases, even in our lower courts, there must be victim impact statements. So we are still working towards getting victims properly exposed and properly shown to the court in all our cases, not only in Section 105A cases.
But how can you show a victim when the victim is dead?
His family is there. I can tell you what I'm going to do in my case now. The family has made a video of the deceased from his birth right through to his wedding, and somebody very close to him, his sister, will be narrating that to the court and will be telling the court who was this man and how great was our loss.
Advocate Francel, I can tell you now, defense advocates and defense attorneys will not agree to that.
They will not even ask a question. They're too sorry to ask a question when that happens. They just stand up and say, "No question, my lord," and sit down.
Because that might not influence the way the judge was going to think. If you are now going to bring a video of the deceased and show the court what the deceased did.
The most important thing when a trial process, be it under Section 105A or any other, what is being brought before the court must be relevant. If then there is an element of wastage of time and irrelevance and perhaps even prejudice on the part of the accused person, you must bear in mind that the accused person also, in terms of the constitution of this country, is entitled to a fair trial. If then bringing of certain information that may be irrelevant or perhaps prejudicial is then brought up before the court, there should be an objection to that.
Do you want to make a comment around the relevancy of...
Of course it will be relevant, because when you get to the sentencing phase, sentencing is about the offense.
But when it comes to the videos being shown...
No, go ahead.
In court, I would definitely object to that, because it would be tantamount to sensationalizing now the case itself. Perhaps that information is only relevant when it comes to sentencing.
Okay, let's hear what the prosecutor has to say.
Sentencing is about the offense, then the accused, and also the community's interest. And all of this, we know, there must be a measure of mercy instilled in all of this. But sentencing is not only about the accused, as many defense counsel would like to make it seem. That is why we can do things.
Councillor, I actually mentioned something that I wanted to get back to, the community concerned. Indeed, the community should be, or as much as possible, must be part of the process of the carriage of justice, as you would find a jury verdict, for instance, in the American criminal justice system. But however, we must always also be wary of the fact that with people that are not so knowledgeable and learned in law, there will always be an element of over...
Quickly, isn't that part taken by the defense in mitigation or the defense in aggravation?
Generally speaking, right now, my comments are based mostly...
Just give a chance, Mr. Giyose. Let's finish this with Mr. Mike Nogag.
Generally, now, we're mostly concerned about the outcome of the case, that is in the process of Section 1.5 capital A, which is mostly about the sentence. So hence, my comments are mostly presumably within the sentence portion of, or the sentence part of the process of prosecution. So I was referring to the sentence. Indeed, this person, that is the accused person that is being punished, is a member of the community, and it must still be considered how desirable or undesirable he is as a member of the community, and very much of how much has he offended the community. So the community, indeed, I'll make an example, must be taken into consideration. I'll make an example.
A few seconds.
For instance, in a situation of sexual offenses, you've got women's organizations, women against abuse organizations of that nature. Their word then perhaps could be, on specific circumstances, be valuable and perhaps even worthy in a court of law.
Well, we'll continue our discussion here with Mr. Nogaga, Mr. Advocate Van Zyl, and Advocate Giyose down in Cape Town. We'll be back after the break. Please stay with us.
That goal was outstanding.
Made so much dust that I couldn't see, and I hit a stone, and we had a puncture.
Catch all these and more every day on Sports Live at 8:30 p.m. on the SABC News Channel.
Welcome back and to our discussion on the plea bargaining system that we have in South Africa. Gentlemen, the one thing, in a foreword to the Draft Victims Charter by the then Minister of Justice, Honorable Jeff Radebe, wrote, "It has been determined that the victims often want more information on what is going to happen and to be kept up to date with developments in their cases." Are victims kept up to date? Or is their view sought? We have actually said that their view is sought. But what I want to know, do we have this victims charter?
I pass this question to my colleague.
Well, you may find that in practical terms, within the practice of law, there is a very consultative process that involves victims. But it is not so much formally a part of law as Section 105 capital A has made plea bargaining to be. And perhaps, who knows, maybe in the future such would become, or the need may rise for the Victims Charter to be part of the Criminal Procedure Act.
Can I just say, in Section 342A of the Criminal Procedure Act, there is a section, a part of the section that has not yet been put into operation, where they were looking at compensation to all victims of crime. But if one just thinks of the idea, I mean, last year we have finalized 506,000 cases. You can think the kind of money involved. So I think there's a financial problem to implement that at the moment. But involving victims, we do as good as we can, but I still think we can do better.
Mr. Giosa, you wanted earlier to get involved in an issue I raised with Mr. Nogaga here, and that was the issue of the involvement of the community to taking care of the community. Isn't that dealt with?
Oh, yes.
As I said, isn't that dealt with regard to when it comes to giving evidence in mitigation or giving evidence in aggravation?
Look, to me, one thing that you must understand when it comes to sentencing, it's but a very difficult part of the proceedings, wherein a judge or a magistrate alike has to do a balancing act now. What he needs to do, or he or she needs to do, is when sentence is about, or rather when sentence is going to be imposed, one, the judge or a magistrate alike needs to take into account the accused personal circumstances. Secondly, the seriousness of the offense itself. Thirdly, the interest of the community, and then impose the just sentence.
It is clear, listening to all of you gentlemen this afternoon, that the coming into plea bargains agreements, they have been balanced against competing values. The values of, should I accept that the state is fair? Because many people say it favors the accused.
I think we are slowly getting used to the system. In the early years after 2001, there were very few of these agreements. But you remember, I wanted to tell you about the statistics.
Okay, let's hear the statistics now.
In the financial year 2014-15, there were 1,760 sentence and plea agreements in South Africa, which is quite a lot, and which immediately deals with this perception that some people say that it's only for the rich, it's only for the powerful, it's only the guys that have, those guys who have it in their pockets who will get this kind of agreements. It goes much wider. It's there for everyone.
Well, it is. People say it's if one looks at, for instance, one case, the Mark Thatcher case, many people said, why did this Mark Thatcher case come to an agreement so quickly? Is it because his mother was Baroness Thatcher?
Well, it will go back to what.
Look, but to me, can I chip in there as far as?
Let's give Mr. Giosa a chance.
Go ahead, Councillor.
As far as plea bargaining is concerned, and whether it's for the rich or the poor, I remember back in 2006 when I was working for the Legal Aid Board. All of us understand that when it comes to legal aid, it's only the poor people that benefit from it. Now, that said, though, I dealt with many plea bargainings whilst working for them. So that notion or that saying that it favors the rich, it's not true.
Thank you very much, Mr. Giosa. Mr. Giosa, we've run out of time. I just want...
When the big fishes are
Mr.
litigated,
Giosa.
then only.
Mr. Giosa, thank you.
Yes.
We've heard what you wanted to say. We have a few minutes, few seconds. I just want to touch on one thing, probably make you guys happy. Is plea bargain a form of restorative justice?
Well, you can easily build a sense of restorative justice into it because, for example, you can have a partial suspended sentence, suspended on condition that the person does certain community services, that one repays certain debts, or whatever. So certainly it can be used as restorative justice as well.
Indeed, I agree with counsel quite absolutely. The suspended sentence with such conditions which introduce into the accused person's life a form of community service and the payment or some form of repayments of whatever the loss was incurred by the victims very much restores the flavor of that was removed from society. And indeed, it is very much in line with the philosophy of restorative justice. And in my opinion, it is my desire that it will be more publicly known so that it can be more utilized in the future.
While plea bargains may assist in more efficient handling of criminal cases, it can provide an invaluable tool to complex prosecutions. It does not necessarily contribute to the perception of fairness in a criminal justice system or developing a positive attitude towards the rule of law. This has been Rights and Recourse. This program is repeated at 10 tonight and 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon.